the same vein, the Quran, Surah Ra'd, provides in 1338 that for everything there is a time prescribed by God. My Lord, the retiring justice, indeed today is undeniably yet another significant milestone in your life. It is the time you retire, and you retire meritoriously, without any dent, blemish, or scar. My Lord, I was only invited last afternoon to represent the body, and haven't realized that my Lord has reached the apogee of his professional career and has been at the Supreme Court for almost a decade. My Lord deserves the greatest attention from the body of senior advocates of Nigeria. Hence, I was able to come out with something scribbled, and I believe it's been shared. But having listened to His Lordship, the Honorable Chief Justice of Nigeria, who has chronicled the lifetime and story and up to date about His Lordship, who is retiring, I think there is no need for me to repeat that, which was also rehashed by the Honorable the Attorney General. So I'll skip that. Your Lordship's colleagues, members of the legal profession, and the larger society have all met here today to tell your Lordship's story once more. We have gathered not only because it has become conventional to do so, but to publicly and formally, as well as openly acknowledge and appreciate the remarkable contributions your Lordship has made to our profession, jurisprudence, and institutions of justice during your Lordship's time in service. I will borrow from the wisdom of the great philosopher Socrates, who said as far back as 399 BC, which is about 2,400 years ago, that four things belong to a judge: to listen courteously, to answer wisely, to consider soberly, and to decide impartially. My Lord was known for all these qualities. Like all great men, your Lordship is a man of unrivaled wisdom, unquenchable thirst for knowledge, and passion for substantial justice. With a radical stance for justice and rule of law, your Lordship has immensely contributed to Nigeria's jurisprudence, as evidently demonstrated in your Lordship's landmark judgments, which solidified numerous principles of law on various issues. Indeed, your Lordship has set the pace for generations to come. As a result of your Lordship's uncommon dedication, tenacity, teamwork, intelligence, and hard work, your Lordship has achieved an uncommon level in his professional career that God, in his infinite mercy, reserves for just the selected few. On an occasion such as this, it is customary to review and acknowledge the strides and efforts of the honoree. We do this to show that sheer grit, tenacity, and readiness to make sacrifices are virtues worthy of emulation and very much fashionable. Even still, in our present generation, borrowing from the wisdom of Mahatma Gandhi, satisfaction lies in the effort, not in the attainment. If we take it a step further, imagine a life filled with efforts and regaled in attainment. Such is the professional life of Honorable Justice Musa Dattijo Mohammed, a life filled with efforts as well as attainment. After reading Honorable Justice Musa Dattijo's profile, I am convinced that his Lordship's life story should serve as an inspiration for all of us, especially the younger members of our noble profession, of both the bench and the bar, who need role models for guidance. Although the honor measured in time, given by this occasion to reflect on Honorable Justice Musa Dattijo Mohammed's achievements in our legal jurisprudence may not be sufficient, it is imperative that His Lordship has made significant contribution to the development of the law and advancement of our legal system. His Lordship's decision demonstrated clarity and precision of thought, as well as capacity to use the law as a tool for substantial justice, rather than dwell on technicality, which serves as a hindrance to the rights of the aggrieved. His Lordship's judgments were always rooted in law as well as wisdom. We must not forget His Lordship's lifelong interest in using the legal system to promote social stability and development. As a jurist, His Lordship was inclined towards substantial justice rather than technicalities, and can be seen in numerous appeals that His Lordship sat on. One of them is the case of Thomas against Federal Judicial Service Commission, where His Lordship, on the effect of an application brought under a wrong order or rule of law and court, held that the requirement that parties state the rules of court by virtue of which they assert a relief is technical and merely prescribes procedural steps for the guidance of the parties and the court. In that case, His Lordship reiterated that the essence of a court is to do substantial justice, and that once a remedy is provided for by any written law and it is properly claimed by a party, the remedy cannot be denied the party simply because he has wrongly stated the rule of court under which the relief is sought. His Lordship was indeed an exceptional jurist. I had the privilege to mentor His Lordship's daughter, the brilliant and well-behaved Fatima Musa Mohammed Dattijo, who worked briefly at my law firm. Fatima is currently doing well within the profession. I am pleased that she went through the firm and the firm went through her. Along with the members of the legal profession, both of the bar and the bench, I have followed with admiration His Lordship's journey through the bench. His Lordship is a father, a role model, and mentor to me, and has been an indefatigable icon in the temple of justice. I have also had the honor of appearing before His Lordship a couple of times, and I'm grateful to God for that. It is very clear and lucid that I stand here, like I said earlier, on behalf of the body of senior advocates of Nigeria, BOSAN. Let me also use this opportunity to reiterate and reiterate BOSAN's usual cooperation and commitment as far as the judiciary is concerned, particularly towards the enhancement of administration of justice in Nigeria. BOSAN can always be counted as a partner, and we, the members, are partners in progress in the promotion of the cause of justice and the judiciary in Nigeria. Furthermore, my lords, and on behalf of BOSAN, it is crucial that I impress on the NJC, the National Judicial Commission, on the urgent need to expedite the process of appointment of additional justices to the Supreme Court in order not to overburden my lords, who are still in active service to this nation, particularly considering the volume of litigation dockets at the Supreme Court and the number of justices attending to them. The need to appoint additional justices is very imperative now that ever, because this is an election year, and the Supreme Court will have numerous election matters which are time-bound and to attend to. Admittedly, there is no provision for the minimum justices which the Supreme Court can have part-time, as Section 320, subsection 2B of the Constitution of the Federal Republic of Nigeria, 1999, as amended, only provides that the Supreme Court can have such number of justices not exceeding 21, as may be prescribed by an act of the National Assembly. However, there is no gainsaying the fact that the present 10 honorable justices at the Apex Court, who are already overburdened, will be further overburdened. I therefore vehemently appeal to the relevant authorities to urgently look into this and take immediate necessary steps to address this fundamental issue of national importance. My lords, the judiciary is the third arm of government, and it has been listed as the third in the Constitution. That notwithstanding, the judiciary is the oldest arm of government, in contradiction to the other two arms of government, that is the executive and the legislature. The judiciary is the wisest and the oldest, and to my mind, I humbly say that it is the primus inter pares and the first among equals and the most important, because it is the glue that holds and puts together this nation. I must not conclude this address without applauding the justices of the Supreme Court of Nigeria for addressing the appeals emanating from the decision of the Presidential Election Court in good time. It is paramount and impressive that this matter has been put to bed timeously. It will also not be out of place to use this occasion to re-emphasize and remind political players, members of the public, and legal practitioners on the need to accord respect to the judiciary. All the political players in our democracy must give the judiciary the needed support to work and perform their judicial functions without intimidation and harassment. Members of the public are enjoined to be circumspect with how they criticize the decisions of the court and talk down on the judiciary, and any attempt, whether directly or indirectly, to intimidate or cow and or suppress the judiciary must be condemned and discouraged in all ramifications by all well-meaning Nigerians. However, this does not restrain, prohibit, or preclude lawyers, researchers, academics from constructively analyzing and criticizing the decisions of the court. We are practicing a democracy. We all must know our limits. Whether you are a lawyer, whether you are a judge, whether you are an executive, whether you are a parliamentarian, whether you are a member of the public, yes, we know that we have freedom to speak, but we must know our limits. For our judicial officers, courage, probity, and independence should be indispensable attributes. It is in the interest of the society at large that our laws are interpreted and decisions given in line with current realities and developments. Law, they say, by its nature, is not static, but dynamic. If I may borrow the words of Master of the Rolls, Lord Denning, in Parker and Parker, as far back as 1953. I wasn't born, and many were not born. If we never do anything because it has not been done before, we shall never get anywhere. The law will stand still while the rest of the world goes on, and that will be bad for both. By way of concluding remarks, my lords, as rightly stated by Abraham Lincoln, and in the end, it is not the years in your life that count. It is the life in your years. It is only appropriate that I conclude this address by congratulating His Lordship on the ability to promote discipline in the legal profession during His Lordship's tenure on the bench. His Lordship consistently advocated for legal practitioners to maintain the highest moral standards in order to earn the public's trust and preserve the integrity of our profession. By this occasion, the reality has now dawned on us that we will no longer enjoy and benefit from services of His Lordship on the bench as he bows out of the judiciary. Some of us are forced to ask this question. Why do all things, good things, have to come to an end? But we also know the answer. On behalf of Musa,